All right, the last case for the morning is S.M.K. versus S.L.E, C.C., and M.C. Anytime you're ready.
Quick as I can.
All right.
Are you ready? Good morning. Well, it's afternoon almost. Bill Gressley from Jacksonville on behalf of the appellant. I'd like to reserve 5 minutes of my time for rebuttal, which is usually an aspirational goal rather than reality. Opposing counsel and I briefly spoke at the beginning of this and recognized that this type of case is among the most difficult that we ever have to deal with. And it takes us legally into the area of where angels fear to tread. I think that the real key here is the trial court's misunderstanding and misperception of what the evidence actually was, and even assuming he didn't believe a word my client said and believed everything anybody else said. We've still got a fundamental legal problem and a lack of clear and convincing evidence. My client's right to be a father is of constitutional dimension, and I don't think there's any argument about that. Where it gets less clear and harder to analyze is, what does this require the law to do when a termination of parental rights is sought? And I have fundamentally assumed, and I believe it's accurate, that a finding like we have here that says my client, who is the father, is not entitled to be heard to object. His consent to an adoption is not necessary. That is a termination, substantively a termination of parental rights. Under the statutory and case law, you have to have clear and convincing evidence. I think the big factual context here for this should not be lost. We have a couple, my client and the mother, who lived together for several years, got pregnant. For as far as we can tell, they were mutually supportive. There is no other inference. They supported each other. They lived together as a couple. Got pregnant. They had a child in Florida. A few weeks later, they moved back to my client's home in Indiana, to a house that he had there where he was planning to get it renovated where they could live. The unrebutted testimony from my client was that at that point he had $4,000 in account, and that he was going to use that to renovate the house. He used it to take care of the couple and themselves and their baby. He took care of the baby. The mother did not dispute that he had helped take care of the baby. And then they had a big fight, and evidently that part of their relationship, and she decided she didn't want to be there anymore and felt like she needed to go back to Florida. Her mom was from Jacksonville. Her sister lived in St. Johns County, which is how...
There was some dispute as to whether that was just a temporary thing and they were going to be coming back to Florida, correct?
Her actual testimony was that she had thought they were coming back to Florida, and my client told her when they were there that he was never coming back to Florida. I think that was part of the disagreement that led to her surreptitiously leaving with the baby and moving back to Florida. I think that what we should keep in mind when we analyze this case and when this court comes to reach a decision is that we have a young lady who admittedly had substance abuse problems, primarily alcohol, been rehabbed twice, had ongoing issues about being consistent being a mother, which was clear from her testimony and from her sister, who is the appellee. who decided she didn't like the fact that she had a baby with a man she no longer wanted to be with. And so what's the solution here? Well, the solution is we give the baby without any notice to the father, to her sister, says to herself and to the world that sister will be much better at taking care of a baby than I will, and she lives on a boat. We terminate the father's parental rights. She never has to deal with the father again, and she gets to see the baby whenever she sporadically feels like it. I'm being not cynical, but that is what the unmistakable inference from what has happened here is, because the evidence that there's two issues that are legally, in my submission, critical. One is the trial court's assertion that my client should have known where the baby was and should have done more. Secondly is this issue that he should have been paying support. Neither one of those are supported by anything other than marginally relevant evidence, certainly not clear and convincing.
There was some testimony from her on those issues, wasn't there?
I'm sorry?
There was some testimony from the mother of the child that he would have known where the child was at.
Her testimony was that she could probably produce a text message that she told him where they were. She didn't produce one. She never testified, I told him that this is where they were. Now let's put this in the context of what we know from the record. The first time my client knew where his child was, for sure, really knew, was when the joint petition to find his objections none necessary for an adoption. He had already filed a paternity action here and had been adjudicated to be the father of this child. That was never in dispute, which is a fact that the judge, and I believe statutorily, is incorrect in his whole analysis about this abandonment theory, because the case law that he relied on has to do with a father who never acknowledged his paternity for months and months and months.
Let me ask you this. So the joint petitions filed, was it June or July of 2016?
Yes, and the petition for paternity was entered the day that was filed.
The petition for paternity had been filed in May and granted in June.
And he was adjudicated to be the father,
Right.
And then the petition's filed.
Okay.
And
well, let me finish my question.
I'm sorry.
So you have the petition to establish paternity filed in May, it's granted in June, then they file the joint petition, your client gets served. So you just said at that time your client knew where the child was.
That was the first time.
Okay. Between that day and December, well, when was the first time there was support payment made from?
You mean after
After your client unquestionably knew?
It's a few months, but here's how this happened.
Was it 6 months?
I believe it was December, because in September is when my client, he had his rights to visitation. They had an order entered that said he gets supervised for a few weeks because the baby's an infant, and it progresses to unsupervised. The trial court never, ever entered an order on...
Regardless of whether there's an order, my question was, if the petition for the adoption was filed in June or July, when was the first time there was a child support payment made, whether voluntary or by court order?
I think it was in December, and it may have been January, but here's the...
When did the visit start?
The visit started in September, or right after the adjudication of paternity and the time sharing. He did 6 weeks or so of supervised and then went to unsupervised, and he never missed a moment that he had the right to see his daughter. The issue about the child support...
3 months with no support, right? After the visitations were granted, then there was no support for 3 months, correct? No support payments?
Yes, and there was no support ordered, and there was no support amount determined. And my client filed an affidavit, and it was his attorney, my co-counsel, Steve Alexander, who said, and said this in open court at the hearing, I'm the one who came up with an amount because there was never any amount adjudicated. There's never been any child support worksheet. And more importantly, as a matter of due process and constitutional law, a failure to pay support all the time is not justification for termination of parental rights. What is the thing about this case that has to be kept in mind, my client has exercised his right as a father, including support, every chance he has had. Was there a few-month period? Yes, but what happened was he spent a better part of a year with a P game, a shell game, where's the baby? He never got a straight answer. The mother kept saying, well, she's with my mother, which turned out to be false. The mother of the child went initially to her sister, the S.L.E. Then she left and took the baby with her. Then she ended up with her mother at some point and ended up in a physical altercation and left. She then went back to her sister's house, left the baby, and then went and stayed with a friend. And I stuck it in a footnote that the friend appeared to have addiction problems, and the mother ended up in the ER for dehydration. This woman was moving all over the place. Okay, so now we get the joint petition to terminate my client's rights, and now he sees where she has in fact been. He tried to find this child. Could he, if he had more money and more resources, could he have hired a private investigator to track the mother? Yes, but
Let me ask you this, and don't go outside the record on this, but was there anything in the record, he filed the petition to establish paternity in Indiana in November, and then he filed one in Florida in May. The trial judge seemed to, point to those dates as an indication of not.
I'm sorry, I missed.
Well, with regard to the November, is there anything in the record as to why that was dismissed?
In Indiana?
Right.
My recollection, and this is an inference I'm reading from his voluntary dismissal, is he's filed a petition in Indiana where the child was not conceived or born or was residing.
Okay, so that's the extent. There's no real testimony on that. Okay, and is there anything in the record on why the petition wasn't filed in Florida until May?
The only inference, and this is coming from the trial testimony and the comments of counsel, his counsel, my co-counsel, Steve Alexander, is that as soon as he was retained in May, my client gave him 3 addresses: the mother on her boat, the maternal grandmother in Jacksonville, and the sister, the S.L.E. in St. Johns County. And that's how they finally figured out where this child was. And if we're going to split hairs so badly, then I think we have to at least acknowledge that there's no clear and convincing evidence that my client knew anything except that he was getting a runaround.
All right, and let me ask you this. The statute refers, the end of the story doesn't end with failure to pay support or failure to see your child regularly. It also references whether it evinces an intent to reject parental responsibilities.
That's correct.
Okay, so could you enumerate what things that your client did that do evince, an intent to accept parental responsibilities? I mean, I think obviously filing the petitions evinces an intent. So I'm asking you to enumerate.
And I appreciate that question, because I think that gets to the heart of this, is whether this is either statutorily authorized or constitutionally permissible. My client has always been the father to this child, and I don't mean just biologically. He has been there since the beginning. He supported the mother and the child. He took them back to Indiana to a home that he was going to renovate to have them have a home there. That led to an argument with the mother. So that whole time, he was the father. There was no suggestion that he was operating in any other capacity other than this child's father. As soon as he got here and was able to get counsel and start the process, he did everything possible to find them and to assert his right to be her father. He never, ever missed a beat on visitation whatsoever. He cooperated with the S.L.E. They asked, because of some school break with their existing children, to switch a weekend, and he said, okay. But he never missed, and he drove from Sarasota to St. Johns County every other weekend to be able to see his child. He's talked about the money that he had spent on her, the things that they did together. Everybody who saw them together that testified, the only people with firsthand knowledge, said they love each other. My client loves this child and wants to be their father. The only reason that this conversation is happening and this legal issue arose in this context was because the mother decided she didn't want him in the picture anymore, and she was not capable of being a mother.
You have children with other women that he did not father, that he did not visit, did not support?
Judge, that's a really good question. The judge cited that as taking judicial notice of these prior files, which are 4 years old at least. my client, there's more to that story than just the fact that there was this prior order, and I can't answer it because there's nothing in the record except that the judge took judicial notice. But what is critical...
Well, what was the judge taking judicial notice of?
Oh, that he had abandoned prior children, or that he was, no, not abandoned them, he had failed to support them. So this is the bad character evidence. Oh, he did this 5 years ago with other family, with another woman, and he owed alimony, and so he's doing it again. That's not legally permissible. But what's important, I think, is page 4 of the order that's under review. The judge underlined, well, he said he didn't really go look for his child, and he didn't pay any support until he's court-ordered to do so. He was court-ordered to do so because my client asked the court to adjudicate him the father and to set time-sharing and child support. My client instigated that. It's not like they had to drag him into court. He instituted this. He wants to be his child's father. The judge says, underline, this is Judge Alexander, if he had done so, paid support, this result would be different. Then he underlines the next sentence. He knew the mother was either living with her mother in Jacksonville or with the Churchills in St. Johns County. And well, what he left out is or on her boat in Brevard County, or with her friend, the drug addict, and who she ended up in the ER. He did not know. There is not sufficient evidentiary support for the conclusion made by the judge that my client should have known where the child was. What's telling here, and I submit is dispositive of this whole statutorily and constitutionally backwards notion of
The
abandonment.
record reflects that she testified that she had told him where the child was. Is that?
No, what she said was, I told him we were here in Florida. We had come back here. And she had ongoing text messages with him, the nature of which she basically said was abusive, et cetera, et cetera. And when Mr. Alexander asked her point blank, did you ever tell him where the baby was? She said, I'm sure there's a text message somewhere. Well, she never said in court where the child was and that she had actually told him that, and she never produced a text message. So the real issue here is the only clear and convincing evidence is that my client loves his child and has wanted to be a father, and for every moment that he has been legally allowed to access her and spend time with her and support her, he has done so. The reversal of this is required, and I've got 4 minutes for rebuttal. Thank you.
Good morning. My name's Brian Calloway. I represent the S.L.E in this matter. And before I get into my prepared argument, I'd just like to address the last question that was posed to the appellant regarding testimony, whether or not the mother informed the father about where the child was in their conversations in early November of 2015 through February of 2016. The mother did testify that they were in constant contact via text between each other during that time frame. But I think it's important to note, as the judge noted in the order which denied the appellant's motion to dismiss the termination petition, the judge in that order, it was a very specific order that addressed the issues that were going to be addressed on this joint petition. The court informed all the parties that the father has an affirmative obligation of demonstrating compliance with the statute that the court used to terminate his parental rights or to determine that his consent was not necessary for the adoption. And I think it's important to note that the mother did testify that she was in contact with the father. There's absolutely no testimony.
Was there any direct testimony of any witness that prior to July of 2016, that the father was told the child is residing at such and such address, or with such and such relative?
No, there's not. But there's also a lack.
So does that mean that he was supposed to send support to, he was supposed to guess where to send support, or what?
It's easy to not find someone if you don't take any affirmative steps to do so. There's absolutely no testimony.
He's filing petitions. It's not like he's not doing anything in an effort to find the child. And there's never been a dispute that he's the father of the child, and yet they're really hiding the baby.
That actually, there's no testimony from the father that that's the case. There's no testimony from the father that he inquired as to the location of the child at any time, either to the mother or to the adoptive parents. And there is testimony from the adoptive parent that the father has her cell phone number, had called her in the past prior to the split between the mother and the father. He had contacted her via social media.
What is the fact that as soon as he is served with the petition and knows where the child's at definitively, that he makes every effort to then see the child?
Well, that's not really. Are you talking about the first petition, or are you?
I'm talking about the petition to dispense with his consent.
Well, again, I don't think that he did take every opportunity to see the child. He did file the petition, but he did not make any affirmative steps other than doing that to contact the child when he had reasonable knowledge of where the child.
He testified he called your clients and didn't get through. Is there any evidence that your clients called him?
No, there's
Okay.
not.
Is there any evidence that but you already said there's no evidence that he was ever told the child resides at this location?
No, that's correct. There's nothing on the record, but there was one phone call made. There was no voice message left. There were no subsequent calls to the adoptive parents, and the father did testify.
Was there any dispute that he contacted the FBI or to do a...
No, there's not, but that brings me to another point as well.
Was that an effort to locate the child if you contact the FBI?
It was a minimal effort because actually it was, my point goes more towards the wellness check that he ordered from the St. Johns County Sheriff's Office. Now, he ordered this in, I want to say, February of 2016, after the mother and father ceased communication. He testified, or I'm sorry, the adoptive parents testified that the sheriff's office did come to the resident where the child was residing, inquired about the child, and was informed that the child was actually residing with the adoptive parents. It's important to note that the testimony from the father stated in this hearing that he never heard anything back from the St. John Sheriff's Office after the well baby check, and he never took any steps to follow up with it. If he had...
Ask you this, was there a scheduled meeting in Daytona Beach? Was there evidence of a scheduled meeting between the father and the mother?
There was.
And was the child supposed to be
No,
brought to the meeting?
No, Your Honor, the child was not going to be present at that meeting. It was just between the father and the mother.
And when was that meeting scheduled to take place?
It was scheduled in February of 2016, if I remember correctly.
And so is it uncontroverted that that meeting didn't take place because the mother decided not to attend?
That is the testimony.
Okay. Is the fact that he scheduled the meeting with the mother for February in Daytona Beach, is that evidence of wanting to exercise parental responsibility?
I don't think that I don't know that the record shows what the intent was behind that meeting. I know that the record reflects that there was an email sent around that time. I don't...
Why do you set up a meeting You know, unless you're trying to establish relationship.
I mean, that would be the, I mean, that would probably be the understanding behind it, but there's nothing that was specifically elicited in the testimony that was a meeting to address the custody or time-sharing issues.
Do you agree that effectively terminating a parent's parental rights is a drastic step?
I do, Judge, but
It's not a best interest of the child standard.
I understand that, Your Honor, and the legislature does as well. And the legislature gives the parental rights constitutional protection, but it's not absolute. And in order for the constitutional protection to attach, the father's expected to demonstrate a timely and full commitment to the responsibilities of parenthood. And it's clear from the records and the findings of fact made by the judge, based on clear and convincing evidence, that the father did not take steps to develop a substantial relationship and accept full responsibility for parenthood.
Did the father file and request that the trial judge set a child support amount?
No. And again, I know that's a big argument as to why the father failed to pay support for 14 months after the mother left Indiana with the child, but I don't think that the intent of the legislature it should be a voluntary standard to demonstrate that you.
Well, if the father knew that the child could be in one of three places, and that's the extent of the knowledge, I know the trial judge eliminated the mother, I'm not sure why, but if the trial, even if it's two, if the father sends money to the wrong place, does he have a right to get it back, or is that money just gone?
Well, I would say that if he were to have sent it to the maternal grandmother or the adoptive parents, payable by check with a memo that.
Able to whom?
Payable to.
Mother?
Well, I would say, yeah, probably the mother at that point in time.
But if the mother didn't have the child, then that wouldn't be money going for the support of the child.
Well, I think that it's a family relationship between the.
Well, but you don't know, you send that payable to her, and she's not taking care of the child, and she's, as represented, he has substance abuse problems, that money's gone, right?
Potentially.
Once the trial court granted visitation, did the father ever miss an opportunity to be present with the child?
No, he took advantage of the supervised and unsupervised visitation once it was granted by the court.
And that included quite a bit of travel on behalf of the father's part, correct?
It was. At the time he was living in Sarasota. But I would note also that there were no calls in between those.
Oh, and what phone call do you have with an infant?
No, well, I mean, to check on the welfare of the infant.
Because these people had been so cooperative with him that that's what he should do. I mean, yeah, I get the fact that you don't want to be traveling with a little baby. I mean, I understand that, but they weren't making it any easier for him to establish a relationship with the child, and I don't think the relationship was a friendly one, was it?
I can't say. I don't think that it's reflected in the record one way or the other, whether there's any animosity between the father. And
Certainly weren't meeting them halfway for visitations, were they?
No, they were not.
Well, the mother wasn't sharing an apartment finder with the father saying, here, rent this space down the street from where I'm living, correct?
No, she was not. But really, there's three arguments that the appellants have raised in challenging the trial court's order, which determined that the consent of the father was not necessary. The first is just based on the sufficiency of the fact-finding made by the trial court. And I'd just like to mention that the standard of review, which the Florida Supreme Court noted in adoption of baby EAW, is that when an appellate court is reviewing the findings of a trial court under a clear and convincing evidence standard, it's not to conduct a de novo proceeding and reweigh.
So what clear and convincing evidence was in this record that he should have, that he knew where this child was at? Not should have, not could have, not maybe, but that he actually, knew where this child was at.
Well, there's testimony from the father that there was a 50% chance, one of two places, that the child was residing. And again, it's the burdens on.
They lived in a gated community.
That's correct.
Did he make efforts to go to the community and wasn't allowed in?
He went to the community one time, according to his testimony. I don't know if he attempted to go in or was turned away by security, or whether or not he noted it was a gated community and decided to leave. But again, it's very minimal attempts made by the father.
Well, in May, he filed a petition to establish paternity and asked the court to establish support obligations and time sharing, correct?
Correct.
So that would at least indicate that he's telling the court, you decide time sharing, you decide support, which to me indicates that he realizes if a support obligation is imposed on him, he's got a legal obligation to pay.
Sure. But he also has an obligation to provide voluntary support as well to the child in order to protect his parental rights. And that was, again, made clear.
Does that obligation to provide voluntary support assume that he knows who is taking care of the child so that the money, will go to the custodian of the child?
Well, he certainly knew who was taking care of the child when the visitation was, during the time that the visitation was ordered, and still failed to pay.
So the argument is that because it was failure to pay between August and December, August and January, that in and of itself supports a termination of parental rights for the father?
Well, I'd say with that coupled with the failure to do so prior and the minimal efforts that the judge found that were made in order to do so by the father. And the findings of the judge when applied to the statute that he used to determine consent was unnecessary by the father. Established that the order was entered properly, and it should be upheld.
Thank you, counsel.
Thank you.
Briefly, Your Honors, I always say that, and it never happens. Page 143 of the transcript. This is the issue of what the mother told my client. Susan told me multiple different things on any given day to the point where I will never find out where the baby is, to the point on the same day where she was with her mom. So I had to try to decipher what I thought, and I did not fully know. The next question is, where did you believe the child, or whether the mother was living in January 16? My client testified, I was unsure. I thought that she was probably being shuffled back and forth between possibly more than one residence. I even possibly thought she may have moved to the boat, and she was telling me whatever she wanted me to hear. Let's go to this testimony about the attempt to go to Nocatee to find the sister. My client's actual testimony was that he went to the gated community, to the guard gate at this gated community, had the guard call the home. There was no answer, and his testimony, which was not rebutted, was that the guard tried multiple times, and my client sat there for several hours. He then testified, and his trial lawyer, Mr. Alexander, explained this to the judge. I told him if he went back, he might get arrested, and that he should probably call the police or the FBI, and that's what led to the FBI call, and that's what led to the well baby check. The actual testimony about the well baby check was that the officers went looking for the mother, because that's where my client assumed the baby would be, with the mother. And the mother wasn't there. They told the officer they had the baby, but there's absolutely no evidence whatsoever that this information was passed on to my client. The inference from that is that they said the mother was not there. We went to check and she's not there. There are lots of cases, and given how the argument's gone, I should have probably put them in my brief, and I'll certainly submit them as supplemental authority. Tons of...
If they're not, you can't argue them.
Oh, no, just, it's the issue about making payments to some unknown source for unknown purposes. You got 3 or 4 possible options to make child support payments. The case law is legion with people claiming, oh, well, I paid for braces, or I did this, or I did that, and that was child support. And the court said, no, that's not child support. You did that voluntarily. It's a gratuitous act. And you're right. That record shows that the mother of this child had serious issues, and giving her money was like throwing it away with no ability to ever say, oh, that was for child support. Should my client have paid for that few months until we got an agreement between counsel as to how it would happen? Sure, we wouldn't have to talk about it today, but it's not legally dispositive. What's dispositive is that this order is without an evidentiary basis on the important legal points. It is not clear and convincing, and my client has a constitutional right to be a father. He has been trying since this child was born to be a father. Every chance he's had to be with this child, he has exercised it. He has paid support ever since the court established an amount, which was done by the attorney making it up, because the court never received evidence, never made any adjudication of what the amount should be. This order needs to be overturned, and the case to proceed accordingly.
Overturn our own court, can we?
I'm sorry?
Oh, you said this court needs to be, you mean the lower court? Oh, got it. Okay.
This court needs to overturn the order under review.
Okay.
Thank you.
All right. It's too late in the morning to make jokes, I guess. All right. Thank you for your arguments. All right, we'll be in recess.